So in the last class we were studying about voting. Now we shall be starting about resolution. Now what do you mean by a resolution? Once a motion is accepted in the meeting, it is called as a resolution. And resolution is a formal and final decision of the meeting. Whatever happens, because it is being taken by the taking by the permission of the all the shareholders which are present in the meeting. So let us study about resolution and its types. Resolution. A resolution accepted in a meeting is called as a resolution. A motion accepted in a meeting is called as a resolution. A resolution is a formal and final decision of meeting. No discussion is allowed on the resolution. Every resolution should be recorded in minutes book. Every resolution should be brief and framed in the affirmative form. Number of members voting in favor and against the resolution should be mentioned. Resolution should be drafted in present tense. Resolution cannot be altered. So, resolution is a motion which is accepted in the meeting. Then it is a formal and a final decision which is taken, and it should be recorded in the minutes book. Then it should be in brief and framed in affirmative form. Means what? Affirmative means positive statements should be formed, and no negative comments should be given on the same. Then the number of members voting in favor and against the resolution should be also mentioned, and resolution should be drafted in present tense and cannot be altered. Once a resolution is taken, it cannot be altered. Now, next, types of resolution. First is ordinary resolution. Section 114. A resolution which is passed by a simple majority is called as ordinary resolution. More than 50% of the votes should be in favor of motion. An ordinary resolution need not be submitted. The registrar of companies, the notice of the meeting need not require to explain the particulars of an ordinary resolution. For example, approval of statutory reports, alteration of the share capital, the declaration of dividend, approval of directors, auditor report and final accounts, election of directors, appointment of secretary and auditor, and fix their consideration, etc. So basically, ordinary resolution is passed by simple majority and is called as a ordinary resolution. So in that, more than 50% of the people have cast their votes in favor of the motion, and ordinary resolution need not be submitted to the register of companies, and they do not require to get an approval in the meeting and do not require to explain the particulars of the ordinary resolution. Then, for example, what things are included under ordinary resolution are approval of the statutory report, alteration of share capital, declaration of dividend, approval of directors auditors report, and final accounts, election of our directors, appointment of secretary and auditor, and fixed their consideration, etc. So these all things are considered under ordinary resolution. Now, after ordinary resolution, we shall be studying about special resolution. The resolution which is passed by special majority is called as a special resolution. It is passed by 3/4 or 75% majority. The number of votes in favor of motion should be uh, three times of the votes cast against the motion. Purpose of passing a special resolution should be mentioned in the mentioned in the notice of the meeting. A special resolution is passed in general meeting only. Notice of special resolution has to be given 21 days before the meeting. A copy of the special resolution must be filed with Registrar of Companies through e-filing on MCA portal within 30 days of passing resolution. So, firstly, it is passed by special majority, and at least it is passed. See, in ordinary resolution we had more than 50% votes. Now in special resolution we have 3/4 or 75% majority. Then it should be in favor of three times of the votes cast against the motion. Then, purpose of passing the special resolution should be mentioned in the notice. 21 days clear notice has to be given to each and every member of the meeting. Then, whatever is to be discussed in such meeting, it shall be mentioned that special resolution regarding this topic has to be passed. So, this meeting has been convened, and each special resolution shall be passed, shall be taken in a general meeting itself. No special meeting for that is required. Then whatever is happening in the special resolution, it must be filed with the register of companies through e-filing on the MCA portal within 30 days of the passing of the such resolution. Now, examples of special resolution. Now, what are the examples of special resolution? First one, change in the name of the company, shifting of the registered office of the company from one state to another, alteration in the object clause of the company, reduction in authorized capital of the company, articles, alteration in the articles of association of the company. So basically, firstly, if we are changing the name of the company, secondly, if shifting the registered office of the company from one state to another, then alteration in the object clause of the company, reduction in the authorized share capital of the company, and alteration in the articles of association of the company. So these are the special resolution. These are the examples of special resolution. Then, resolution requiring special notice. Some resolutions require special notice as per the Companies Act or Articles of Association of the company. Hence, such resolutions are called resolution requiring special notice. Special notice resolution may be ordinary or special resolution. A proposer of the motion has to give a special notice to 14 days of the to the company. The company should be then give a notice that of that resolution to all the members at least 7 days before the meeting. Now, resolution requiring special notice. What is this? So this is specified in the Companies Act and also in the Articles of Association. Hence, these are called as resolutions requiring special notice. And special notice resolutions may be either ordinary resolutions or special resolution. And whoever has given such a such a new or such a motion, in that case, special notice has to be given 14 days to the company, and the company should give a proper notice to all its members 7 days, at least 7 days before the meeting. Now, what all things come under this resolution? So, under the Companies Act 2013, for the following resolutions require special notice. Firstly, resolution to appoint a person as auditor, the auditor other than a retiring auditor, providing a resolution providing that a retiring auditor should not be reappointed, resolution to appoint director other than retiring director, resolution to remove a director before the expiry of his term, appointment of a person as a director in place of the director removed. So what do you mean by this? So these all things are to be considered when a director is appointed or when a director is to be taken into consideration. So these are the different types of resolutions which require a special notice to be given to the holders. Then next we have resolution requiring registration. Now the some resolutions even require registrations under section 117. Resolutions are required to be registered with the registrar of companies are called as resolutions requiring registration. Resolution should be filed with the registrar within 30 days of its passing. Examples of such resolutions are following. All special resolution made by the board of directors regarding appointment or reappointment of a managing director, resolution made by members regarding dissolution of the company. So, resolutions which require registration. Firstly, all special resolutions require registration. Then, secondly, resolutions made by board of directors regarding appointment or reappointment of managing director, then resolution made regarding dissolution of the company, and resolution shall be filed with registrar within 30 days of its passing. So whatever we so now with this we can come to a conclusion that whatever happens or whatever it is, if there is a process of registration, we shall inform it to the registrar once the resolution is final or finalized by the company. So these are some examples of resolutions which are requiring registration. Now next, after this, we shall be studying about resolution by circulation. When directors have to take important and urgent decisions and do not have sufficient time to call a meeting, at that time a draft resolution is prepared and forwarded to all the directors to pass resolution. It is called as resolution by circulation. So, when there has to be a decision which has to be taken by all the directors in together and important and urgent basis, but do not have sufficient time to call a meeting. So, in that case, they draft a resolution and forward it to all the directors to pass the resolution. It is called resolution by circulation. So, these are the various types of resolutions which can be passed in the meeting. Next, we have validity of resolution. Now, when does a resolution be valid? Resolutions passed at the meeting by following proper rules and regulations are termed as valid resolutions. If resolutions are passed without following proper rules and regulations, they are termed as invalid resolutions. Points regarding invalid regulation. Resolution is not within the scope of notice of the meeting. Resolution passed at the meeting but not properly convened and constituted. If the facts of a special business is not mentioned in the notice of the meeting, if resolution requires a specific majority of votes but it is passed only by ordinary majority of votes discussed at the meeting, resolution is out of the scope of memorandum of association. Voting on motion is irregular. So, what are the points which we shall be considered as invalid resolution? Firstly, which is not within the scope of the notice and meeting, then it is passed at the meeting but not properly convened or constituted. Certain discussions are taking place, but there is no proper decision over certain matters. So, in that case, that resolution shall be invalid. Then, special business is not mentioned in the notice of the meeting. Then, if resolutions require specific majority of votes, but it is passed only by ordinary votes, then resolution is not in the scope of memorandum of association. So, as we know that we cannot function or the company cannot function beyond the powers of the memorandum of association. So, if whatever action is being taken, it shall be done within the scope. Then voting on the motion is irregular. So the motion was voted, but it was irregular. So in this case, it shall be held that the resolution is invalid. So with this, we come to the end of the resolution part. Now next, we shall be starting about the minutes. Now, what do you mean by minutes? Minutes means it is a written record of all the proceedings or whatever happens or whatever is taking place in the meeting. So, meaning minutes, the term minutes written records of proceedings of the meeting. So, what are the requisites? Means what? That firstly, whatever happens in the meeting has to be recorded in a written form is called as minutes. Definition. According to MC Kuchal, the term minutes means a concise and uh, accurate official record of the decisions taken at the meeting. Minutes are prepared by the secretary within 15 days after the meeting. Minutes are recorded in the minutes book and written in the past tense. After preparing minutes, it should be passed in consecutive meetings consecutive meeting. Minutes books for general meeting and board meeting are maintained separately. So remember, these are prepared by the secretary within 15 days after the meeting, and it is recorded in the minutes book and written in past tense because it is recorded after the meeting is over. And the after the preparing minutes, it should be passed in a consecutive meeting, and minutes book for board meeting and general meeting are maintained separately. Two separate books are maintained for each, and record is maintained right from the first meeting till date all the meetings. These books are properly recorded. Since nowadays it is electronically, so it has become easy to save all the data which is required for such meetings. Next, we have importance of minutes. Authentic record. Detailed information about proceedings of the meeting is made available through minutes. So, it is easy to see what was discussed in which meeting and what decision was taken. And it is very easy to understand that why this decision was taken and how it was being taken. Then, next, we have evidence. Minutes can be used as prima facie legal evidence in the court of law in case there is any problem in the business, or in case anyone files a case against the company. In that case, it shall act as an evidence for the court also. Future reference. Minute is a permanent record. It is useful for taking future managerial decisions. Legal provisions. Minutes are to be prepared by following legal provisions mentioned in the Companies Act and Secretarial Standard. Information to absent members. Minutes help the absent members in knowing the proceedings of meeting, and it also serves as a reminder of the subject. Information about resolution. The motion and discussion on the motion are reflected in the resolution. Interested parties can always refer to the text of a resolution where there is contradiction or confusion. So, firstly, it is used for future reference. Whatever, in case in future, if we require for a reference, minutes book is always available. Then, legal provisions, it can be prepared and mentioned, and all the secretarial standards which are mentioned in the Companies Act are to be followed in this. Then information about absent members helps in knowing about the absent members and knowing the proceedings of the meeting, and it also serves as a reminder of the subject. Then information about resolution. Whatever resolution or whatever was the motion or discussion which had taken place earlier can also be seen in such book. Then inspection of minutes. As per Companies Act minutes book should be kept at the registered office of the company, and every member has a right to inspect the minutes book of the general meeting. So, now, everything which is written in the minutes book can be inspected by every shareholder or every member of the company, and hence it is to be kept in the registered office of the company. And secretary has the entire knowledge of which book is kept where, and what all books are to be shown to the members, and what all is to be discussed in case there is any discussion related to earlier chapter. Now, next we shall be studying about difference between motion and amendment. Now, what is a motion and what is a amendment? Motion is a written proposal placed before the meeting for discussion and decision. An amendment is an alteration or a modification proposed to be in the original motion. So, motion is a written proposal which is placed before the meeting for discussion and decision. Then, amendment is an alteration. Alteration means, amendment means, in short, we are making changes. Purpose. The main purpose of motion is to discuss and to take proper decision. The main purpose of an amendment is to revise or modify the main motion. Then effect. When motion is accepted by majority in the meeting, it becomes resolution. When an amendment is approved by majority, it becomes a part of the resolution. So basically, motion and amendment are two different concepts, and each one of them has different provisions to be studied. Then next we have motion and resolution after amendment. Now, what is the difference between a motion and a resolution? Motion is a written proposal placed before the meeting up for discussion and decision. Resolution is accepted motion in the meeting. So, motion comes first, then comes resolution. Once a motion is accepted, it is called as a resolution. Amendment. Now, motion is subject to amendment before it is put to vote. Once resolution is passed, it cannot be amendment. It cannot be amended. Recording. A motion is not recorded in the minutes of the meeting, but all resolutions are to be recorded in the minutes book. Filing. Motion need not be filed with the registrar of the companies. Certain resolutions are required to be filed with the registrar of the companies within 30 days of the date of its passing. A withdrawal. It can be withdrawn by mover before it is put to vote. Once it is approved, it cannot be withdrawn. So motion is earlier stage and resolution is the final stage. Types of motion can be formal motion, substantive motion. Resolutions are of three types: ordinary, special, and resolutions requiring special notice. So these are the three different types of resolutions which are being passed. Then next we have agenda and minutes. Agenda is a list of business to be transacted at the meeting, and minutes is the statutory record of business transacted at the meeting. Importance: agenda is sent to members along with the notice of the meeting. It is useful to the chairman to take items for discussion according to agenda. Members can prepare themselves for the meeting. Minutes: it is a prima facie evidence in the court of law and it is useful for future reference. So agenda is something which goes before the meeting, and minutes is something which goes after the meeting. When it's prepared, agenda is prepared before the meeting, minutes are prepared after the meeting. Tense: agenda is always written in future tense, and minutes is always written in the past tense. Where recorded, agenda is included in the notice of the meeting, minutes is recorded in the minutes book. So uh, this was about agenda and minutes. Now next we shall be seeing about voting by show of hands and voting by poll. So firstly, voting by show of hands is a method of voting in which members cast their votes by raising hands. Voting by poll is a method of voting in which every member is given a ballot paper to record his votes according to the number of shares held by him. Secretary votes are given openly by show of hands, hence secretary is not maintained. Secrecy is not maintained. Voting by poll, votes are recorded on papers, hence secrecy is maintained. Voting by proxy, proxies are not allowed to vote under this method. Proxies can vote only in this method. Number of votes: one man one vote is the principle of voting in this method. One share one vote is the principle of voting by poll. Therefore each member can vote in proportion to the number of shares held by him. Effect: the decision by a show of hands is cancelled when poll is demanded. The decision taken by poll is final and it cannot be cancelled. It is binding on all the members of the company. So this is about voting. Then next and the last one is ordinary resolution and special resolution. Now what do you mean by ordinary resolution? What do you mean by special resolution? The resolution which is passed by a simple majority of votes is called ordinary resolution. The resolution which is passed by three-fourth majority of votes is called as a special resolution. Ordinary resolution requires more than 50% of the majority of votes. Special resolution requires at least 75% of majority of votes. Example: appointment of auditors, declaration of dividend, election of directors, etc. Change in the name of the company, alteration in the object clause of memorandum, reduction in the share capital of the company, etc. So basically ordinary resolution is flexible as compared to special resolution. Or in ordinary resolution, minimum 50% of the majority of votes is required. For special resolution, we require 75% or three-fourth majority of the votes. So with this we come to the end of the seventh chapter.